Wait. They're saying she's removable because she married her boyfriend before admission as an unmarried child of a U.S. citizen? And you're planning to concede removability? No, absolutely not. Let me stop you right there. Just because USCIS says your client was improperly admitted and your instincts agree, that doesn't make it true. What's OPLA's exact basis for claiming deportability? Right. They say the I-130 was automatically revoked because she married, so she wasn't eligible for the visa. But here's what they're missing. Look at 8 CFR 205.1A3. The petition is revoked if the child marries, yes, but only if the beneficiary marries before the beneficiary's journey to the United States commences. Those exact words. You're telling me she flew from her native Antigua to Barbados, where she got the visa, to the Bahamas, where she married, then to the United States. Think about this carefully. When did her journey to the United States commence? I'd argue it commenced when she left Barbados with that visa in hand, heading ultimately for the United States. The marriage in the Bahamas? That happened after her journey commenced. She didn't return to Antigua to live. This was a stop on her journey. Don't give up on this argument. Make OPLA prove when the journey commenced. Force them to define it. OPLA bears the burden here, not your client. Because if you win this point, she was properly admitted and isn't removable at all. But let's say you lose that argument. These temporary judges might not grasp the regulatory nuance. You need a backup. If the judge sides with OPLA on removability, immediately assert relief under INA Section 237A1H. This is the fraud waiver for those inadmissible at time of admission, even if there is no misrepresentation. Your client has a U.S. citizen child with her husband, right? She qualifies. Now, here's where you look brilliant. The regulation does not require any particular form for 237A1H relief. None. Ask the judge directly. Your Honor, for my client's 237A1H application, would you prefer we file an I-601, or can we proceed without the form since the regulations do not require any specific form? So your strategy. First, fight removability using the journey commencement argument. Document exactly when she left Antigua, her intent, the continuous nature of her travel. Second, if you lose, immediately pivot to 237A1H without assuming you need a Form I-601. Your judge, if new and not too well trained, may not know 237A1H exists, let alone that it doesn't require a specific form. You're educating them while advocating. That's how you protect your client. Never concede removability when there's a regulatory argument, and always know which relief provisions don't require forms. Because the difference between looking prepared and looking lost, that's what clients remember if they lose.